We do have some good news because there's been a couple Canadian citizens that just won a couple bail hearings using the Canadian Bill of Rights. Well, all right. Welcome, everyone. And today we have my wonderful friend, Jane Scharf, with us. And if you don't mind, Jane, I'm sure a lot of people already know who you are because you've been so awesome and, working very hard when it comes to the laws of this land that we call Canada. But just in case, would you mind introducing yourself for the folks?
Okay. I refer to myself or like to describe myself as an activist. I've done one type of project, protesting primarily for pretty much all my adult life. A lot of it was in the area of advocacy for poverty and disability, but I'm also very involved with this COVID stuff and the convoy charges. So I work with Stand for Thee, and we assist people who have decided to self-represent, and we give them as much support and guidance as we can to bring their case forward.
And you do have a paralegal background.
I do, but I don't act in that capacity with Stand for Thee.
With that said, we do have some good news because there's been a couple Canadian citizens that just won a couple bail hearings using the Canadian Bill of Rights.
Yeah. And a motion. And a motion. So two bail hearings and a motion, yeah. And
those are actually on record, aren't they?
Yes, they are. All three are.
Wow, that's amazing. That is absolutely fantastic. And so that's what today is really, really, again, about, to really show the difference about self-representation, because ultimately what we're trying to do is empower people to know their rights. And there was a gentleman back in, we'll say 1960, that managed to get the wonderful Canadian Bill of Rights, right, into law with royal assent, inshrined, and we'll talk more about that the next time we talk. And of course, this is something that those folks who want to control a lot, they're not crazy about the Bill of Rights. They prefer the Charter. And so, you and Rebecca and Stand for Thee and Dave Freedom and Kelly Hale, and of course myself, I'll throw myself into the mix, and my good brother Dom here, we're trying to show people, well, listen, we think the Canadian Bill of Rights is a lot better when it comes to your civil liberties, whereas the Charter is working against you. And of course, I just heard that Mr. Peterson lost using that Charter, right? And I know he's going to appeal, and et cetera, but you've got a couple, I won't say you, but some great Canadian citizens did get a couple motions, a motion and two bail hearing wins with the Bill of Rights. So let's get one of the subjects that you and I have talked about a lot is we want to talk about, hey, what happened to the jury? We want juries on civil liberty matters, so we don't have just like one person in, one of those fancy gowns making a decision. And what we are going to talk about, if you don't mind, first of all, let's talk about the subject of jury and why that might be quite a bit more advantageous to the Canadian citizen. Why do you think juries would be better to make a decision, if you will, more so than one state paid judge? I mean, obviously for us, we kind of think it's a no-brainer, but I think it's good to explain it.
Well, there's a number of reasons why a jury is a good idea. Primarily because it's the method by which we the people, remain sovereign. And it allows us to keep the government in check. So if every time any power is exerted, a group of citizens considers and analyzes the situation and approves before it happens, that keeps things in check.
And you're kind of sampling. Right?
Yeah,
go ahead.
It was invented for that purpose out of the gate, and it's part of our common law history, long-standing common law history. But since the communist attack on Canada began in the 60s, they've been trying to obscure that right. And they didn't get rid of it because you can't. That's the beauty of common law. They can't kill it. They have to suppress it and distract from it and shove it under the rug like they did with the Bill of Rights. And we're finding out, more and more about the jury as time goes on. I was just looking at a jury as someone who can try the facts, and they're more independent and impartial than somebody from the state would be if it was any kind of political element to it. So I always thought from that perspective it was better. But now I'm looking at other elements of a jury's authority, and what's come up recently is the understanding that a jury has the right to analyze the facts and decide if a person is guilty based on facts, but they're also authorized to analyze the law that the person's been charged with, and if they find that the law is inappropriate, unlawful or just like not a good law, they are allowed to override that law and nullify the charges, and in so doing, they nullify the law itself.
Wow! So that would help. That would help prevent nefarious, unrighteous decrees and policies and mandates. Yes. That could be a great advantage if you got a tyrannical GOV that decides to invent some policies and mandates, like some of us are suggesting they did fairly recently. This might give the jury some power, clearly, and of course we are going to put a link later on so you guys can check it out. But we actually have you guys discovered some case law from 2006 that actually authenticates what you just said.
Confirms it. Yeah,
confirms it. That is amazing.
Kind of a convoluted dynamic that was going on there. What happened was the judge or the jury was starting to question the law. So the matter got appealed, and at the appeals court, it went all the way up to Supreme Court. Actually, the Supreme Court finally decided that the jury. First of all, the court cannot instruct the jury. Like, that's a long-standing factor that came from the William Penn case in 1600s. But this judge was disregarding that. And then the Supreme Court confirmed that the judge they can inform the jury, but they can't instruct the jury. You know what I mean? They can tell them about the law or, whatever, but they can't say, you can't do this or you must do that. So they confirmed that the Supreme Court confirmed that the judge can't instruct the jury, and they also confirmed that the jury can nullify law. And then they did one sort of thing that I wasn't happy with, because they said, although the jury can nullify law, the defense lawyer cannot inform the jury that they have that right. So if they just happen to know they have the right, then they can exercise it. If not, which is really nonsensical. But regardless,
that's a little strange. But regardless, so that goes to show you.
Yeah. So the main thing is nullification is still there, but where the problem is, they've over the years they've reduced the opportunities where you can have a jury, and it's almost down to nothing now. Like from every. Like in the Magna Carta, it's supposed to be every claim made against you. And we found some early case law that shows that jury was provided automatically as right for summary charges. And
that goes to show you how important it is, because again, just to kind of reiterate, when you have a state-paid judge, right, making the decisions on your case, well, for lack of better words, what are the odds of that person being able to be impartial in your case, and you're essentially, committing yourself to one person's opinion, rather when you have 12 people, you're getting a sample of different walks of life, right, from different perspectives, and if something is certainly inappropriate, well, then the 12 will agree regardless of, what their history is or how wealthy or unwealthy they are. That's the idea. might men, you might have women, different folks. So you get different perspectives. And then what happens is that allows an opportunity for someone to say, well, look, I disagree with what this person's done. And then somebody else goes, well, hold on a second. I kind of have a different perspective. And there's a whole thing on that. So it's not so easy to condemn people so quickly. Whereas if you have a state paid judge, the odds of that state paid judge coming against his own state that funds him or her, well, that's going to be a lot more difficult.
It depends on what the charges are, right?
Right.
Like if you punch your neighbor in the nose and the charge is assault, well, I think the judge is pretty independent and impartial in that case. But when it comes to the situation with the COVID charges, for example, or the convoy charges, they're not independent of the state. They're a party of the state. And the very definition of independent means you're not dependent for sustenance. And the judge is dependent for sustenance. So they're not independent. So
if I were to simplify this for folks,
for two, for the impartiality, which you described perfectly, and then you need it for the independence. Because if you don't have that independence, there is a conflict of interest, not just an appearance of one. There is one.
Right. So that's great. That's really good. There just is one. So like you got jury equals independent of court and therefore impartial. Court, if you will, equals judge, which equals dependent, right? Which means automatically not impartial immediately. All right. So why don't we grab the Canadian Bill of Rights? Are you cool with sharing that, good brother Dom? Because we want to show you how in the Bill of Rights, where this right, if you will, is, because it's not necessary. Oh, please.
Story of Dave Freedom wanting to sit John Diefenbaker down and ask him, why did you put a right to a jury in the Bill of Rights? And I said, Dave, I'll answer for him. It's like, okay. So I said, well, look at 2E. Can you see 2E? Is it big enough for your audience?
It's right here. Here's 2E. And
okay.
Do you mind if I read it out?
Go ahead.
It says, so the front end of this, by the way, it says, every law of Canada shall, unless it is expressly declared by an act of Parliament of Canada that it shall operate, notwithstanding the Canadian Bill of Rights, be so construed and applied as not to abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared, and in particular, no law of Canada shall be construed or applied so as to deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of his rights and obligations.
That's a very strong statement because it shows that the court is supposed to be factoring in the assessment of your rights automatically in what they're doing. It's not just about you've done something wrong and whatever we do to you in the process of bringing you to so-called justice is examined, because there's lots of topics that go with that. Excessive use of force, arbitrary arrest, unreasonable bail conditions, not having the right to counsel, and also an arrest can interfere with freedom of speech, assembly, association, religion, the press, all those kinds of things. So those things need to be looked at by the court, and that guarantees it right there.
And then in conjunction with 2F, okay, so this is in the Canadian Bill of Rights, Section 2. We just read 2E. We're going to read 2F. It says, no law of Canada shall be construed or applied so as to deprive a person charged with a criminal offense of the right to be presumed innocent until proven guilty according to law in a fair and public hearing, and here's some good words here, by an independent and impartial tribunal, or of the right to reasonable bail without just cause. So again, there's those words impartial, independent and impartial, and we know that a state paid judge cannot be those two things.
Exactly. So John would say today, I didn't put the word jury in there because I recognize the politicians at the day would have been having their backs up with having a right to a jury because that diminishes their power. So he
Right.
put it in there in full bloom, but without using the word, so that he didn't, set off a reaction. So
So
I think
bottom
it's
line
there
is,
just as firmly as anything, and there's no conditions on it. It's you. They're charging you. They're going to give you a jury. That's it. That's all. Say goodnight.
yeah, I could almost argue by reading this actually that a judge on his or her own actually cannot actually judge on a civil liberty matter, particularly when there's any kind of charges that enter into the criminal zone, if you will. I mean, the way I'm reading that is, well,
unless you agree, right?
Unless you agree,
you can forfeit if you decided you wanted a judge instead of a jury. You could do that, but you have the right to it. So that's really what we're on about. And
that's amazing.
With regard to Byron Carr, he was a trucker charged in a convoy, and originally they were dealing with him extremely aggressively, treating him. They called him middle management. That's what it says in their paperwork. And so he was being treated as an organizer. They arrested him. He spent 41 days in jail, and they were just deplorable conditions. And then after that, he had a lawyer, and they treated him as though he was an nth degree criminal. They basically banished him out of Ontario. He had to go back to Alberta. He had to have 2 sureties. He had to maintain an address with, like, if he moved from any address, he has to get permission from the court to move from one address to another address, even within Alberta. And then he also had a social media ban that said he could not use any social media for any reason. And even though his charges had nothing to do with social media anyway, but regardless, they stuck that on there, and also banished him from Ottawa. He can't go to Ottawa. And then, he like the way they were acting towards the ones that were considered organizers, they were talking 5 to 10 years in jail. The Crown was looking for. So that's what he had hanging over his head for a year and a half, and he wasn't getting any feedback about how he was going to be defended and what his chances were, and nothing changed. Like, the lawyers didn't change the bail conditions, nothing, just kept going on and on and on, and it really distressed him. He was very distressed about it. So then finally he decided, that's it, that's all. I'm going to take matters into my own hands. And he dismissed the lawyer and decided to do self-representation. And then after he did that, he sought out Dave Freedom and asked if he would assist him. Dave said, yeah, I certainly will. And within a week, after they found out that he was self-repping, they offered him a deal. First movement, first any indication of any activity after all this time. And they offered to not drop the charges. If he pleaded guilty to all 4 charges, they would give him 6 months probation. So a big deal from 5 to 10 years in jail to 6 months probation. And he said, no, I don't want to do that. I'm not guilty of anything. I'm not pleading guilty to anything. So then a couple of days later, they decided he started talking about jury. As soon as he started talking about jury, they said, no, it's summary, no jail, summary. Okay, because they don't want him to have a jury. So then they had a judicial pretrial, and they reduced the charges from 4 to 2 and tried to get him to change the wording in one of the 2. And Dave told him, no, don't do that. And it looks like they're going to have to drop that charge, because I'm guessing they were trying to change the words because it was improperly defined. So that charge is probably going to be gone. So the only charge he has is having a truck in the street.
Which, of course, we know he has the right to protest, and without exceptions, as far as I'm concerned, no Section 1 loophole, which we'll talk about. But I have to tell you, based on what I just heard from you and what I'm reading here, he's supposed to be presumed innocent until proven guilty. And ultimately, what the person did was show up in Ottawa with a lot of other people and put his truck in one lane and said, I'm against these mandates, which he has the right to do. And again, if we don't get people to understand that jury is important and the Canadian Bill of Rights provides provides that for you in 2E and F. Now, let's explain to people how this is not quite equal in the, well, I call it, sorry, Jane, I'm going to say it, the poo-poo charter. Okay.
Oh.
Sorry, that's how I call it.
Say the bastard court.
This is, I use a little bit of that immature language, the poo-poo charter. Okay, so I get a little immature there, but ultimately it's because Section 24, and there's again that position that we're trying to explain to folks, because there's some legalese here, and it talks about in Section 24, this is the charter, okay, everybody? And this is what it says in Section 24, and I'm going to suggest to you, but Jane is going to further comment on this. It says, anyone whose rights or freedoms, as guaranteed by this charter, have been infringed or denied may apply, they can apply to a court, keep that in mind, to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Now, to the average person like myself, I think court, so, I'm kind of picturing the movies, Law and Order and stuff like that. And I think, okay, judge, jury, lawyers, blah, blah, blah. Not so. If I'm understanding Miss Jane here correctly, this word court equals the same as a judge, no jury. So your access to a jury is extremely limited, and you have to use Section 24 in order to actually activate your complaint, correct?
For your rights, for violation of your rights, there's no jury. Because the matter is being brought to a court of competent jurisdiction, and a jury is independent of the court.
Okay. So here's Canadian Bill of Rights.
You're not getting a jury if you're going to, if the court of competent jurisdiction is fashioning the decision.
And this is your point when you say people...
If you're with the jury fashions the decision. So that's saying the court is fashioning this decision. So there's no jury there.
And this is your point when you say, unless people, right, you have access to a jury, if you will, through the Bill of Rights, for example, unless you choose not to. And by invoking or putting in this quote unquote application, you actually, without realizing it, you're invoking Section 24. And guess what you just did? You consented. You consented to say, no, I don't want a jury. I'll take a state-paid judge to decide whether or not it was my right to to protest in Ottawa.
Breathe free air, with no diaper on, things like that.
Yeah.
Operate my business.
Yeah.
Have a vaccination or not.
Right. All of that stuff is going to be, by invoking Section 24 of the Charter, you basically just said, I'll let a single, very, very, let's just suggest a person with a huge conflict of interest potentially, because the very state that is paying them, you're saying, hey, that group, that state has done something wrong to me, and I'll let you decide whether I'm right or not. Whereas when you go to the Canadian Bill of Rights, not so, right? And you have, you actually, again, I'm going to say this again, if it has to be someone independent, that can't be a judge. And if it has to be someone impartial, that can't be a state-paid judge. And therefore, by using the bill, you now have access and legal right, and you have not chosen to do anything except for, I would suggest the way that reads, you want a jury. And again, that's very advantageous to someone who wants to protect their rights, because the odds of you finding 12 people that are totally, on a jury where they're all in agreements that, you protesting is a problem in Canada, I would suggest that's difficult.
Actually, there was a survey done at the time when the Emergency Act was invoked, and 70% of people reported that they did not agree with the invocation of the Emergency Act. Wow. And then 6-8 months later, they did the same survey and they got the same results again. Okay. So people did not like that. So going into a jury situation, you don't have that bias, of respect for the government's action in that case. They're more able to just, look at the facts and adjudicate. So we believe that Byron can clearly show that the Emergency Act was not invoked legally, which means that the regulations that were brought in, the emergency regulations that were brought in under it, such as the vehicle exclusion zone and no assembly and all these things, are counterfeit.
Right.
So the jury, if you have a jury, because of their right to nullification, they can look at that and say, yeah, we agree with that. And we can like really demonstrate it, because it says for example, this one's a really easy one to show. It says in the preamble of the Emergency Act, in their emergency planning, they're not to violate your Charter of Rights, which is no big deal because they can just say Section 1 emergency, but they're not allowed to violate your Bill of Rights either.
All right. Do you mind if we grab that? That's the one. All right. Sorry. Go ahead, Jane.
The preamble.
You're talking about this section right here.
Yeah.
Okay. And it says, whereas the governor and council in taking such special temporary measures would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are, this is a big sentence in my opinion, that are not to be limited. I'm going to repeat that, not to be limited or abridged, even in a national emergency.
Bingo.
Boom. And
Boom.
This
Emergency Act was illegal.
And one big way we can prove it is because, again, the Bill of Rights is in here. And by the way, a little other side note that we always like to include is that this was assented to in 1988. That's post-charter.
Yes.
That's post-charter. That means it's both. And they were acknowledging that the bill was enshrined and they couldn't budge it, they couldn't move it. And therefore, they had to create this document with the bill included. They couldn't omit it because it's enshrined in our Canadian law. And this is the one they're trying to bury.
It's enshrined in our Constitution,
which we're going to talk about next time. I love it.
Yeah.
Unless you want to talk briefly about it right now, because I think you're talking about in the preamble, correct?
The preamble of the Bill of Rights, yeah.
Okay. So let's you know what? I'm gonna read it, and I'll let you do a little commentary on this as well. I'm gonna read it. This is in the Canadian Bill of Rights, the third paragraph of the preamble, and it says, "And being desirous of enshrining these principles and the human rights and fundamental freedoms derived from them in a Bill of Rights, which shall reflect the respect of Parliament for its constitutional authority, and which shall ensure the protection of these rights and freedoms in Canada."
Yeah, enshrined means contained in, and it means protected by.
Okay, so embedded in, contained in, and protected by.
Yeah. So where else? What else were they talking about? It can't be enshrined in itself. It has to be enshrined in something else.
Right.
So it has to be the Constitution. There's nothing else that they couldn't say, oh, well, it's this or that. No.
Right.
No.
So it's not disconnected because you can't just enshrine it into nowhere. So when they're saying this desire of enshrining it and then talking about the constitutional authority, well, what's it being enshrined, embedded into? Yeah, it's and protected by. It's being protected by the constitutional authority.
That Diefenbaker was a genius.
He really, really was. And I don't mind adding this in because you and I had a little conversation this afternoon about this, that again, why is it worded this way? Well, I think you and I both know he's being especially clever to word it in such a way so that it wasn't glaringly obvious, and yet it's there, much like the two E and F in combination is jury. If you say jury, you're going to find someone who says, well, and they'll make this argument about, you stealing a pack of gum, which is a ridiculous argument, and that's absolutely nonsensical. And then he did the same thing here. And the more we're studying this bill, the more we're realizing that this is why there's certain folks who want to control. I would suggest strongly that they don't want you to know about these things. And that's why they're dodging, and that's why they're trying to push.
That's why they couldn't get rid of it. I always wondered why they didn't just, like put it out there to like get rid of it and to bring in the charter. But it's basically has the status of a constitutional amendment.
I love it.
So that would be very structured, to reverse. Like it's allowed, because first of all, It was after 1931, and UK gave us authority in 1931 with the Westminster Statute to make our own constitution going forward and be an independent Commonwealth country. And we didn't until this. But this is, I mean, the wording, and they all passed it. So
right, because that's what this is about, assented. And so therefore, what we're saying is, because they like to claim, the people who are opposed to what we're saying, they like to claim, well, but that's, yeah, it's a federal statute, but, yeah, it's a federal law, but it's not constitutional. Really? Well, then what's all this about? It's right at the very end. And that's what you're saying. You're saying, well, it's talking about enshrining, and we know what enshrining means: to protect, protected by and embedded in, and it has to be embedded and protected by something and embedded into something. And then it talks about constitutional authority. In 1931, we were allowed to do it, and the entire parliament signed this across the board, and that's why it received royal assent and it was signed off. So therefore,
Her Majesty, by and with the advice and consent of the Senate and the House of Commons, enacts as follows.
Boom. There it is.
I love this expression too, which shall reflect the respect of Parliament. You see, that's the people, we the people, the respect of Parliament, not the respect for Parliament, the respect of Parliament. I love that. That is so empowering. If people let that sink in, let it sink in, let its meaning permeate. We are the people. We are the sovereign.
That's right. And that's why.
Right there. And this is the government signing this and the Queen signing it. So she's agreeing. We are the authorities. We are the sovereign. They are the subjects.
I love it, Jane. Thank you so much for your time with this. I mean, I think we've done a pretty good job at explaining why here, in our opinion, and of course you're going to have to work this out for yourselves, because we are pushing people to rely upon themselves, because we have a country, and again, big thanks to Mr. Diefenbaker back in 1960. That's why sometimes you're hearing Jane talk about John. It's John Diefenbaker. He codified this, if you will, so that the average Joe like myself, all right, unless, of course, the bad people try to trick me out of it, but an average guy like myself can just simply look at this and go, okay, so I have the right to all these things, right, without exception, and the only exception would be if there's no limitation. Yep. And of course, unless, of course, then the criminal code. So if I'm going around breaking people's windows and beating people up, that's a separate thing. That's criminal stuff. And again, even in that case, I still have due process of law, and I'm innocent until proven guilty, et cetera, et cetera. All the things that we really need.
There's a process for creating those things. And then we still have the jury just in case they get carried away with that shit.
I love it.
Juries have overridden sections of the criminal code with nullification.
That's fantastic, because once again, it keeps the folks who happen to, get some level of power from getting carried away. And by the way, just so everybody knows, I know we're pretty, we're pretty staunch about this. But the charter, when we talk about how the charter is different, right? We're talking about this very first section of the charter. The huge difference here is that it basically says that the charter protects these basic rights and freedoms, right? But hold on, let me. Yes, here it is. Section 1
that are set out in it, unless they think they have a demonstratively justified reason to override your rights.
Right.
And so they've said, oh, COVID is a demonstratively. Well, we don't have to prove it. Public Health said it.
Right.
The World Health Organization said it. That's enough. That's exactly how that was interpreted in court with the charter. With the charter.
And by the way, and this is where this comes in, Section 24, you said a judge, right? When you invoke this thing and put in this application, you're saying a judge, right, gets to decide whether it was reasonable for them to take away your right. Whereas with the Bill of Rights, no such thing. No such thing at all. period. And then on top of it, when you have that, obviously we have that 2E and F, where of course we have not only the rights and the fair hearing, but we have the presumption of innocence spelled out here, by the way. And then on top of it, we get access to a jury rather than a state-paid judge, and none of which I would suggest is in the poo-poo charter. And that's why we are certainly reminding everyone that this is enshrined.
And there's one more thing. This
Please.
is just a sneak preview to another show later when we talk about children's rights and protecting children and the parents' responsibilities and rights.
Yep.
I didn't realize how unarticulated the parents' rights were for the children. And I looked at a 1948 supposedly rights of the child, and I was appalled that it actually says in there that the state is a partner with the parent, with the child.
Right.
That gave the heebie-jeebies. But then I consulted our old trusty Rusty here, and if you look at the preamble, it talks about the position of the family in a free society.
Yep. I got it highlighted, by the way. I just showed everybody the position of the family in a society of free men and free institutions. And that, again, Mr. Diefenbaker did something here that can slide by us. But actually, what he just did by saying this is essentially saying, because when you say in a free men and free institutions in a free society, what you're essentially saying is that the family is not an agent of the state.
Yeah, we're not subjects.
Subjects.
Not subjects of the state.
Right.
Because we're free. So we're free to make our own decisions. So we're obviously free to make our own decisions in the family, because he's put family right in there. So obviously the children are in the family. So the decisions with regard to the children are our decision in a sovereignty situation, like in a democracy.
Right.
And if the state has any role at all, it would be a supportive role that we identify and put conditions on, such as we've agreed, most people would agree, that criminal charges can be laid and pursued against people that harm children. We've agreed with that. So we'll let the state do that. But again, with a jury, so that they don't get carried. Okay, right. So there you go. It's a, like, common law has a really beautiful design. It allows us to have some structure and some tradition and process, but at the same time, it has a built-in safeguard for tyranny.
Right, because we talked about that today, that we don't want anarchy, right? And hence we do need, a degree of government. We don't want anarchy. We're not anarchists. But on the flip side to that, we don't want tyranny to take over either. So we have, if you will, a balancing act here, right? We don't want to just toss away good, decent laws, but at the same time...
William Keith says it the way it is. He said, we either have a situation where the state has all the control or the people have all the control. And you can't have a combination because there's no independent arbitrator. So before Magna Carta, the monarch had all the control. They made every decision and they just pulled laws out of their ass, no consultation, no concern how it's going to affect anybody or what they want or what's fair or what's reasonable. Because it wasn't even considered. Like, what they want is what they, and they even put that forward as, they had a right, what did they call it? The right of kings, the God, whatever, God anointed them or whatever, and they had a right of kings. And in the Magna Carta, the people said, no, enough. If you want to remain to be the king, then here's the way it's going to be. And they set down a series of articles that they demanded that the king needed to commit to respecting. And he did. He promised into perpetuity to respect these articles in the Magna Carta. And one of those articles is that any claim made against you, you have a right to be heard by a group of your peers. That's a jury. And not, only if it's a serious crime. No, not if it's, not unless it's a lot of money you're suing for a lot of money. No, any claim made against you. So that'd be civil claim or criminal claim, all, unless you choose not to. So if you want to just go in front of the judge and do it up, then you're good to go. But otherwise, you have a right to a jury, and that can't be That can't be. They can't. What do you call it? They can't appeal it because it's not legislation. You know what I mean? So they can't just put it up and adjust it because it's not legislation in the first place. They have no authority. The state has no authority to touch it.
Period.
Ever.
Right? So all they can do, all they can do is manipulate you into giving that up. That's the only option and strategy that they have. And we here in Canada have this wonderful Canadian Bill of Rights that's staring at us, as well as all the historic evidence here that we don't have to give that up. We just have to root ourselves in what we know is true. And we just so happen to have the blessings here in this country where it's actually documented for us. And Jane, I can't thank you enough for doing this interview with me. I know it's going to bless a lot of people. So we encourage all of you guys just really, really dig into the bill and tell other people about the bill. And it was really, really done so well. And we're going to continue to study it because I think we're going to find some more gems as we continue to read it. And we're going to find how many different ways we're going to be able to protect ourselves in this country from tyranny. And I think that this is going to be really, really, really helpful to not only our generation, but for the generations to come. And I know in my heart, Jane, that this is one of the biggest reasons why you're investing so much of your time and energy and skill into this. And I know Rebecca's doing the same with Stand for Thee and Dave Freedom. And so I thank you. I thank you so much for today.
Well, the thing is, with Dave, he was going to be heard tomorrow with a motion for a jury for a summary charge. And at the last minute, they threw a case law at him that he needs to address. And he's going to address that by filing a constitutional challenge. And he's going to be challenging the jurisdiction of the Superior Court and the Ontario Court of Justice, which we call an illegitimate court, because it doesn't. The Ontario Court of Justice popped up right after we had free trade, and they're trying to shift everything over to there because it has no common law inherent jurisdiction in there, and so it's only a statute court. So we're going to go after the legitimacy of the statute court. And this way, when we get that out of the way, then we're just dealing with the Superior Court, and then we're looking at the inherent jurisdiction of the Superior Court, which includes the process with a jury for all charges against you.
I love it. Well,
and then ultimately for Dave, he wants to have a jury for Byron to hear the defense that the Emergency Act was not brought in legally. It didn't pass through Parliament properly. It didn't meet the grounds to bring it in, and it violated rights. And there's even some other. There's about 5 items that they violated in the Emergency Act itself. It's definitely not legally brought in.
I love it. I thank you so much for spending this time with me. We're gonna do another interview real soon. Am I correct?
Yes. We'll do the next one. We'll do the children. Okay. Issue. We have some strategy for that, and that's why I just wanted to give that little clue.
That little clue.
The position of the family in a free society.
Yeah, that is an absolute huge. Jane is talking about once again. She's talking about this right here. Sorry.
And by the way. Does your audience think that section made it over to the charter?
Ah, right. Because it did not.
No, it did not.
It did not. And this is huge. And anybody who has a family, quite frankly, regardless of your position, of your beliefs, if you have any degree of family, this indeed is huge for you as a citizen in this country. So I'm looking forward to doing this interview. We'll do that for the next one. And again, Jane, thank you so much. Maybe after we kind of shut down this recording, you and I will just talk a few more minutes to set up that next interview. But in the meantime, thank you so much. And keep doing such a great work. And I just on behalf of myself, my brother Dom here, and anybody who might be on my channel listening to this, I'd like to say thank you to you for taking this time and to doing all this work. I just really greatly appreciate you. Thank you so much.
Hey, thanks for having me on, Shade. I think this is a really good topic for your audience to hear. I agree. And I want to remind them to watch Dave Freedom, watch his page, because he posts when he has an appearance for Byron. Byron Carr is the guy.
Okay, and you can find Dave Freedom. I think most people find him on Facebook. Am I correct?
Yeah, it's on Facebook. Yeah.
Okay, great. So it's Dave Space Freedom. It's exactly how you'd normally spell it, and he's on Facebook. And and don't be shy to shoot him a message too, and say, hey, I heard an interview, and Jane and Shade were talking about you, and this way he can be encouraged to know where you got the information, and you might be able to get some more great stuff in what he's doing, because he's doing some great work. All right, thank you so much. And we're on tomorrow night at 8:00 as well. And Say that one more time.
At 8:00 tomorrow night. And there's a number of topics that we'll be addressing. We're addressing 15-minute city and the sexualization of children in school, and self-representation, and Trudeau for treason.
That's great. That's great. Thank you so much. And that when she mentioned Stand for Thee, okay, guys. So maybe some of you know about them, some of you don't. And again, I encourage people to get involved in all these subjects, because all these subjects are really important to every individual in this nation. So get involved, get educated to the best of your ability, put some time and energy into this, because it'll be well worth it for you, your family, and the generations to come.
Yeah, Thank you so much, Jane. We have some easy to exercise strategy for the meat and potato people, and
that's on the Stand for Thee website, right?
Yeah.
Okay, so
the tools we use there, we're supporting self-representation, small claims court, and these are the tools that we can use to defend ourselves.
Yeah, and it really, don't underestimate many people doing a lot of little things, because that can really pack a big punch in the end of it. Okay, guys.
100 people suing somebody, because we encourage them to sue the individual who's doing something, not the agency. So if it's the school and it's the teacher or the principal or superintendent, we want them to sue them as individuals. And we have case law that shows that you are allowed to do that if they're violating your rights or violating the law in some way. You're allowed. They don't fall under their liability protection and so on, and you can sue them as a personal individual. If 100 people sue somebody at $35,000 each, that's $3,500,000.
That'll wake them up a little bit.
Yeah, and the risk is very low. It's capped, because people think, "Oh, I can't afford." Yes, you can. It's $105 for small claims court, and if you lose, you pay 15% for the legal fees. For the other side, you pay 15% of what you're asking for. So for $35,000, it's $5,200, and if that's too high of a risk, you can bring the total down to where you're comfortable.
Right. So you could bring it down to 10 grand, and now the risk is 1,500.
Exactly. And 1,000, 150.
Right.
But still, you're going to make your point with them, and they still have to defend. And even if they win, it's going to cost them $50,000. And if you sue them for $1,000, they're going to get $150.
Right. Right. It's a really I think it's a really inventive strategy, and outside the poo-poo charter box, which clearly, as we've displayed in some other videos, is not working very well for the folks that are using it. And rather, I think that these types of strategies, and it also allows that every single individual on some level can throw a little, shall we say, a little jab to the person in the ribs a little bit. The people who are trying to do things they shouldn't be doing.
And guess what? You can use the Bill of Rights in small claims court, but you can't use the charter.
That is amazing. You can use the Bill of Rights in small claims court, but you can't even bother using the charter. That is fantastic.
Yeah, because they've judged it as not a court of competent jurisdiction to hear a charter challenge.
Wow, that is fantastic.
And you don't have to make a bill challenge either, right? You just bring it up as piece of legislation that supports your position, along with any other, liability act or any other kind of thing that you want to bring forward to make your case.
You can just verbally cite it, is what you're saying.
Yeah, we've used it already, and there's been no objections.
Right.
Remember that 1 year, like it's way back in 2020, I used it just as a part, like it wasn't for the whole motion. But the judge wasn't happy about it, but he accepted it and backed down. Because I said fantastic. He has to respect the bill in all the orders. So I told him he couldn't make this certain order because it was violation of rights under the Canadian Bill of Rights. And I showed him in the Canadian Bill of Rights, it said it applies to all orders, regulations, the law, there's a list. And his was in order, right? So he didn't like it, but he listened.
Well, they're not always going to like it when you're right. That's fantastic. Well, I'm looking forward to doing the next interview too, because I think those subjects that you're talking about are very important, and not only to my audience, but I'm going to suggest to you and all people, right? Because these are our subjects. If you're less interested in one, it's got to affect you somewhere else. I mean, they're hitting at basically at every single solitary civil liberty, and so everybody's going to have to understand that that's very important, essentially to everybody. And as you mentioned, I think we could do a survey even in our own lives that I think most people really appreciate. If they really stop and think about it, they appreciate these civil liberties, and we need to hold on to them, because that's what makes a nation truly enjoyable to live in. And I think that's what we want. We want some joy in this life, and I think that's why so many people worked so hard to make sure we had this enshrined. I'm going to keep using that word, Jane. Enshrined in our country, and it should be now enshrined in us.
Yeah, in our Constitution.
I love it. I love it. Enshrined in the Constitution. It's fantastic. Thank you so much, Jane. Stay on for a little bit. We'll have a quick chat, arrange that next interview. And for all of you listening, guys, thank you so much for spending this time. All right. Thank you so much. God bless.